Good morning, everyone. I'm Johnny Miller. I'm with the Utah Counties Indemnity Pool, which is an entity down at the Association of Counties that the counties created 30 years ago now because they couldn't buy insurance in the traditional marketplace any longer. They created their own self-insurance program, and I work for that organization. And so anytime we burn buildings down, crash vehicles, or get sued, we use money out of that fund to pay for those situations rather than spend money on insurance. And it saves the counties a lot of money over the years. But one of the things that we do to try and keep those costs down as well is train and try and keep claims from occurring. So today we're going to do our discrimination and harassment training. How many of you were told that you needed to go to sexual harassment training today? All right.
Mandatory.
And, you know, almost every HR person calls it sexual harassment training. And yes, we're going to talk about sexual harassment today, but you can't talk about sexual harassment without talking about discrimination, because that's what it is. It's discrimination, as we'll see, and we'll talk about that. But that's what we're here today for. We're going to talk about the legal foundation of discrimination, harassment as a form of discrimination, discrimination statistics, how to report, and talk about investigation of discrimination and harassment here at Box Elder County, and employee responsibilities that you have in the area of discrimination and harassment. Okay. So we start our discussion today with Title VII of the Civil Rights Act of 1964. That's what created sexual harassment in 1964, when they passed the law that says we will not discriminate based on race, color, religion, sex, or national origin as an employer. We will not discriminate for those things. A few years later, a couple decades later actually, Congress passed the Age Discrimination in Employment Act, which added to the list of things we do not discriminate against people for someone's age. So as of then, we no longer can discriminate against someone who's over 40 years of age in the employment arena. Later in the early 90s, I think it was, the Americans with Disabilities Act was passed by Congress, and that added as another protected status someone who has a qualified disability. And we all started dealing with making reasonable accommodation for employees who have qualified disabilities to assure that they're not discriminated against in their employment. So that's our list of things that we need to be concerned about today in this training is race, color, religion, sex, national origin, age, and disability. And those things are referred to by the courts as protected classes or protected status. So when I say protected class or protected status throughout this training, what I'm talking about is race, color, religion, sex, national origin, age, and disability. So again, all of this goes well beyond sex harassment because you can have harassment based on any of these protected statuses under the federal law. In addition to the federal law, though, here in Utah, the state legislature has passed its own, more or less, Civil Rights Act, the Utah Anti-Discrimination Act. And that act does the same thing as the federal law. It prohibits any employer from discriminating against an employee from all the items that we saw that were prohibited under the federal act, but it adds a couple of protected statuses. Under Utah law, we also do not discriminate against employees for sexual orientation, gender identity, or pregnancy. Now, pregnancy, the federal courts have already long ago recognized that harassment based and discrimination based on pregnancy is sex harassment and sex discrimination. But here in Utah, they've spelled it out separately. There are also some limitations under the Utah Anti-Discrimination Act regarding expressions of religious, political, or personal beliefs outside of the workplace that are in there as well. So if that is something of interest to you, that you'd want to go and review the Anti-Discrimination Act to see how all that works. But again, when we're talking about the things that you should not have to deal with in your workday, here in Utah, it includes sexual orientation, and gender identity and pregnancy. Interestingly enough, almost every year, we have a legislator bringing new ideas to add to this list. This year, the proposed bill was to add political affiliation as an item that we could not discriminate against employees for. Now, there's already places throughout the statutes here in Utah that prohibit a government employer from discriminating or harassing employees based on their political affiliation. But what this bill would have done, it would have made political affiliation a protected status, which means you couldn't harass, or co-employees could not give each other a hard time about political affiliation, which sounds good, except the policy would become no discussion of politics in the workplace whatsoever. But that bill did not pass. The other one that was suggested this year was to make hairstyle. Yes, hairstyle, a protected status, that you could not harass people based on their hairstyle or lack thereof. That seems to be the one that I hear the most. But again, we see these come up, and so we just need to be aware and recognize that this list may grow either through legislation or through determinations by the courts. All right. So when we say that an employer cannot discriminate against an employee, what are the courts talking about? Well, the federal law specifically says we don't discriminate against employees when it comes to their recruitment, their selection, their promotion, their discipline, or their training. And that's what the law says, and then eventually through court cases, the courts also consider any other action that alters the terms and conditions of employment are things that we do not discriminate against employees for. So we've seen claims where adverse employment action that was taken by the employer that was discriminatory against the employee, they moved my desk away from the window because I'm a woman. They've changed my shift from the day shift to the night shift because of my religion. Things of that sort that we need to be aware of, and if you feel that any of those sorts of things you're being treated differently because you have a protected status, and it's your protected status that you're being treated differently because of, then you should be reporting that under the harassment policy. Some EEOC statistics. The EEOC is the Equal Employment Opportunity Commission, and this group was created after really when harassment was identified by the courts as a form of discrimination, the courts were flooded with claims, and they couldn't keep up. So they created the Equal Employment Opportunity Commission to kind of screen the cases that were coming to the courts before a judge and jury would have to hear the cases. So the EEOC employees will first go to the EEOC and have hearings, and the EEOC will determine how strong of a case do they have. Do they have the elements that it takes to show the courts that there's illegal harassment going on? And if so, they get a probable cause letter, or what attorneys call a right to sue letter. And with that right to sue letter, they can move on and take their case to court without any fear of repercussions. If you either don't go to the EEOC, or you don't get that right to sue letter, the probable cause letter from the EEOC, and you choose to go to court anyway, if you lose in court without that right to sue letter, and you may have to pay your employer's defense costs because you didn't take this step. So that's kind of the carrot and the stick of the EEOC, is you get a hearing before you're actually in full-blown court to hear your case. But if that doesn't turn out well at that level, you move on to court at risk, or if you skip this entirely. So some statistics from the EEOC, and again, any employee that has an attorney that brings a claim, the attorney is going to have them go through the EEOC, because they do not want their client to end up having to pay their employer's defense costs, and then the attorney end up having to pay that as malpractice to their client. So this is data I got off the federal website regarding charges of discrimination and harassment filed again with the EEOC between 2015 and 2020. And what was really interesting is that the total number of charges and complaints of discrimination and harassment across the country have been going down significantly every year for the last 5 years, but actually I look back and it's been 8 years back before there was even a slight increase in the numbers of total claims that are being filed with the EEOC. Charges of discrimination and harassment regarding sex, race, national origin, religion, age, disability, all of those categories were down, like 30% down over the 5-year period. Cases based on color was the only status where there was an actual increase in the number of cases that were filed with the EEOC during that 5-year period, which is very interesting. I think attorneys are starting to learn what makes a decent case a case worthwhile bringing to the EEOC, and ones that don't is part of the reason for that, and we'll see why they'd be thinking that with some of the other statistics we'll look at. Now, the other charge that we regularly see now with discrimination and harassment claims is I was discriminated against or harassed, and when I complained of it, I was also retaliated against. So that's another charge that the EEOC considers. And while the total number of retaliation charges was also down, it was not down as much as all the other categories. So what that tells us is when someone files a claim for race, sex, national origin, religion, any of those other protected statuses, more of those also include a retaliation claim than they have in the past. That trend is going upwards. And again, retaliation, as we're going to talk about quite a bit, because that is a very important part of our harassment liability. Sex-based discrimination actually accounted for 32% of the charges in 2020 at the EEOC. So what happened with the cases that came before the EEOC? And here, because I know sexual harassment's a really an area, that's what you were told this training was, seems to be the focus in this discrimination and harassment area, and with the Me Too movement, I think, how many think that these are going to show that sexual harassment is way up? And again, we just saw it, actually, the number of charges isn't up, and of the charges that are made. So now these are sexual harassment charges made with the EEOC in 2018. There were 26,700 charges filed. Of those, 1,200, or about 4%, got that reasonable cause letter. 4% of the time, the Equal Employment Opportunity Commission felt that the employee had a strong enough case to move forward to go to court. 4,800, or about 18%, either settled, closed, or were otherwise resolved sometime between the point where it was filed with the EEOC and before the EEOC could hold all of its hearings and come up with a decision and file a decision, which does happen very often. Insurance companies get nervous, employers get nervous, employees, as they start that hearing process, get nervous that maybe their case isn't as strong as they thought. And so they regularly, 18% of the time, those cases get dealt with before there's a decision made. And in over 20,000 cases, about almost 70% of those cases that were filed in 2018, EEOC found that there was not reasonable cause for the employee to move forward because their complaint of harassment or discrimination did not rise to the level of being illegal harassment or discrimination. And that's an important part of what this training is about today is I'm going to talk next about why these statistics are the way they are, that there's clearly a misunderstanding amongst a lot of employees as to what is illegal harassment, because they're bringing 70% of the claims that they bring aren't really illegal harassment. But I would hazard to guess that many more, almost 100% of those claims are violations of their employer's policies. They're things that should have been dealt with through discipline by the employer, but the courts do not consider it illegal discrimination or harassment. So to understand what is illegal harassment, we need to start again from the beginning, where we start with the Civil Rights Act of 1964, where we cannot discriminate against people based on their protected class. We cannot treat them disparately. The first, and again, that Civil Rights Act has not really been changed or updated or amended significantly since 1964. All the differences in the legal climate today regarding discrimination and harassment in 1964 is all the result of cases determined by the US Supreme Court interpreting what the Civil Rights Act meant to do. So the first set of cases that the US Supreme Court was faced with regarding discrimination and harassment were people that were saying that it's not employment so much that I'm being discriminated against, it's my access to government services that is being discriminated against. The government's not allowing me they make me take a test to get my voter registration card. They don't allow people of my religion to practice my religion or to gain access to certain services because they don't understand why I need it based on my religion, things of that sort. And the courts ruled that even though the law doesn't say it in black and white, we believe that was the intent of the Civil Rights Act. And so treating people differently regarding their access to services provided by a government entity is also discrimination. The next group of cases they got were people that were filing discrimination and harassment claims against their employer. You can imagine that early on, what was the response of the employer? If you don't like it, you don't need to work here. Here's your pink slip. And the courts took a look at that and said, no, employees have a right to bring a claim to determine whether or not they were discriminated against or harassed in the workplace. At this point, it's still discrimination. Harassment did not exist yet in the court. They have a right to bring those discrimination claims, and we're not going to allow the employer to discipline them, terminate them, take any other retaliatory action against them because they used their right to go to court to determine if they were discriminated against. So they interpreted that retaliation is also a form of discrimination. And we'll talk about that more later. The next group of cases where, well, the employer is not treating me differently when it comes to my recruitment, my promotion, things of that sort, but they're just harassing me in the workplace based on on a protected status that I belong to. And the courts took a look at that and again expanded the letter of the law to their interpretation that harassment based on a protected status was also meant to be something that was a violation of the Federal Civil Rights Act. So that's where we get harassment being a violation of federal law. As soon as harassment was recognized as a form of discrimination, the courts saw a significant number of harassment claims based on sex. And so that's where the courts took a look at those cases and said, yes, when we said harassment is a form of discrimination, we meant it for all protected statuses, but they coined that phrase sexual harassment. That yes, sexual harassment is a form of discrimination, it's illegal. So that's how we get sexual harassment. But as you can see, it's just one small part of all forms of discrimination and harassment. Like I said, 32% of the claims filed with the EEOC are sexual harassment. The next cases that the courts were faced with was, I'm being harassed at work, and it's not my employer that's doing it, it's my co-employees. They're the ones that are harassing me related to my protected status, and my employer's not doing anything to stop it. The court took a look at those cases and said, no, we think that that's reasonable to require an employer to put a stop to co-employees and others harassing people in the workplace based on their protected status. So they coined the phrase hostile work environment, and they added that to the list of hostile work environment that the employer does not take reasonable steps to stop is a violation of the Civil Rights Act. So that's how we get to where we're at today. So through all of this, the US Supreme Court, their definition of what is illegal harassment, it's illegal to harass anyone in the workplace based on any of the protected activities. And they set out a three-pronged test of what they consider to be illegal harassment and what falls below the level of being illegal. First of all, the conduct that is the basis of the harassment has to be unwelcome. So, as most of us know, first step, if an employee feels that they're being harassed, is they need to let the person that's the bad actor know that's offensive to me and it needs to stop. Or you need to go to your supervisor and tell them, here's what's happening, it's offensive to me, I want it to stop. And the supervisor then goes to that person and lets them know that's unwelcome behavior. But if, from the court's perspective, if you play along with the unwelcome behavior or the behavior, they're going to consider that that wasn't unwelcome and therefore it cannot be illegal harassment. A good example, we had an employee that complained of sexual harassment several years back. And as we were defending the claim, one of the co-employees brought to our attorney a picture of the person's desk. And on the desk was a placard that said, sexual harassment is not only welcome here, it's rated. And that employee was bringing a claim of sexual harassment. And the courts took a look at that and said, we are not believing that harassment was unwelcome to you in the workplace when you have that on your desk. So that's the first test that the court will look at. The second thing they'll look at is the harassment somehow founded in one of the protected classes? Because we get calls all the time from HR directors and others that got this complaint of harassment. Well, what is the harassment based on? Well, the two people played on opposite football teams in high school and they never let it go and they just cannot get along. And so now one of them's complaining that they're being harassed and it's a hostile work environment. It has nothing to do with the protected status. That is not illegal harassment. No matter how disruptive and difficult it may be in the workplace, it's a violation of the county policy almost always, but it's not, in the court's eyes, illegal harassment. Got to be tied to one of the protected statuses. And lastly, that unwelcome conduct related to a protected status has to be sufficiently severe or pervasive enough to alter the terms and conditions of employment in the mind of the victim and from the perspective of a reasonable person in the victim's position. Now, what they're saying there is the jury has to come back and tell us that they agree that if they were that employee and they had to deal with that harassment every day at work, that would affect their ability to do their job well. It would impact and keep them from being able to do their jobs. That's the level that the court has set out as to what is illegal harassment. And again, there's going to be a whole lot of harassment that doesn't rise to this level, that is a violation of the county policy that we want to deal with under the county policy with discipline. But I bring this, I make sure that you understand this because again, with all of those cases, do you think the 20,000 employees that went to the trouble and time and cost to bring a charge to the EEOC were upset when the EEOC told them you don't have an illegal harassment situation here? Wouldn't have they like to have known what the standard is? And that's why I want to make sure that you understand it. I'm not telling you don't bring, don't go to your supervisor and let them know that you feel that there's a hostile work environment or that you're being harassed, but now you understand the level that the courts get concerned about it. Actually here, the US Supreme Court in several cases, they talked about what is less than illegal harassment, and they made this statement in a couple of cases. Title VII does not prohibit all verbal or physical harassment in the workplace. Which is like, what? What? The Supreme Court said what? But they're just pointing out that there's going to be some verbal and physical harassment in the workplace that has nothing to do with a protected status or does not rise to the level that it changes and alters the conditions of employment. And they're just pointing out again, that's not illegal under the Civil Rights Act. Employers should deal with that internally. So their comments in their court cases are that simple teasing and offhand comments and isolated incidents, unless they're extremely serious, are not going to amount to discriminatory changes in the terms and conditions of employment. They won't consider that illegal harassment. Okay? And actually, not only the Supreme Court, but again, I talked about how we have our own Anti-Discrimination Act here in Utah. So not to be outdone by the feds, Utah has also created their own little state, EEOC, which they call the Anti-Discrimination Division of the Utah Labor Department. So if you want to bring your discrimination claim or harassment claim in state court rather than federal court, you would go, instead of the EEOC, you would go to the Anti-Discrimination Division. And I went to their website to get some statistics from their website, which they didn't have a lot, but I found this paragraph right on their front page of their home web page. It's like the second paragraph, set off and in bold, and it says this: an employee may feel that he/she has been treated unfairly by their employer. Personal conflicts, disagreements over management style or personality differences, favoritism towards an employer's friend or family member are all examples of unfair treatment, but do not necessarily constitute unlawful discrimination. And the bold lettering is theirs. That's how it appears on their website. So a commission that was created specifically to look out for and employees in the state of Utah, what that told me was they are dealing with a lot of cases that are being filed with them as well that do not rise to that level of illegal harassment. Again, I'm not saying it's not a problem. Those are all issues that need to be dealt with by going to HR, your supervisor, and dealing with it under the county policy. Because we want to stop that before it rises to this level. Okay. All right. Different forms of harassment. Harassment can be in the form of physical, verbal, or nonverbal. Some physical harassment examples would be actual or attempted rape or sexual assault. And remember I said that the court says that it needs to be sufficiently pervasive or severe enough. Actual or attempted rape or sexual assault is severe enough that that probably only does have to happen once, and the courts will consider it to be illegal harassment. But as we go down this list, I started at the most severe to the least severe, and as we start going down the list, it would have to happen regularly enough that it would affect your ability to do your job. So hitting, touching, hugging, kissing, poking another person, touching or rubbing yourself in front of another person, impeding or blocking someone's movement, shifting back and forth in a doorway or a hallway to not let that person through without bumping up against you. That's a form of physical harassment. Leaning over, cornering, standing too close to someone, hanging around, or brushing up against a person. Those are all examples of physical harassment. So if you see that happening to you, you should be reporting that to your supervisor. With verbal harassment, racial or ethnic slurs, again, that doesn't have to happen very often, and the courts are going to get concerned about it. Pressuring someone for dates or sexual favors, teasing, joking about any of the protected statuses, sexual comments about a person's clothing or anatomy, questions about social or sexual life, and using pet names. And if those are unwelcome and offensive to people, it needs to stop. That's all forms of verbal harassment. Nonverbal harassment can be things like making sexual gestures with your hands or body movements, leering and staring, facial expressions, throwing kisses, licking your lips, looking a person up and down, giving unwanted personal gifts, leaving the flowers and candies and things like that on someone else's desk. That can all be nonverbal harassment. Suggestive or offensive emails, texts, messages, or posters, derogatory posters, drawings, or cartoons. And I gotta flip these two, because when I first started doing this training 30 years ago, I'd go into road departments and stuff to do this training, and the walls were littered with posters and calendars and cartoons and things like that, that today just absolutely you don't see pinned up on the bulletin board or on the wall at the road shop anymore, because they've all gone to emails and texts, I'm afraid. Not better. It's good that we don't have them hanging on the wall anymore, but it's not better that they're in emails and texts, because for those of you who don't know, you can never delete something on the internet. Texts do not get deleted. They're deleted from your phone, but they're still out there, and they can be found. So if you're receiving offensive emails and texts and things, or people are posting things, that again is all nonverbal harassment. If you're offended by it, you should let them know and let your supervisor know. Leaving religious pamphlets on a coworker's desk is actually a case from here in Utah, where an employee was leaving religious pamphlets, and a co-employee said, "I respect your religion, please respect mine. I don't want to see it anymore, please stop." And didn't stop, went to court, and the court said, no, that's a form of nonverbal harassment, and it should stop. Okay, so where do we have to be aware of harassment, and where's goal? Where are we okay that we can go ahead and harass? Well, I don't want to say that we can harass anywhere, but as far as your employer goes, anytime you're on duty, your employer should be protecting you from being harassed and discriminated against, right? So anytime you're on duty, but there's a couple of situations where most people would consider themselves off duty, where your employer, Box Elder County, still owes you protection from being harassed. An example is work-related social gatherings. So if you have a retirement party for someone in your department, and so it's just your department people getting together for that retirement party, you shouldn't be getting harassed at that retirement party. because it's a work-related social gathering. If your department or your shift goes out to lunch or dinner regularly as a department, again, shouldn't be happening there. Employer needs to protect you from that. Business travel. So again, just because you're out of state at a conference or a training, if it's for county business, the whole time you're there, you should not be being harassed by your co-employees. And if you are, you need to report it under the policy. And anywhere else that county business is conducted. Any of you ever have to go to a state agency office, city office, a vendor's office? You come into contact with vendors? Yeah, most of us do some way, shape, or form. In all of those places, you should not have to deal with harassment. So if it's a state employee and an agency that you are required to work with, or a city employee that you're required to work with, and they're the ones harassing you, you need to report that to your supervisor. And the county attorney's office and HR are ready to go to those other employers and let them know the harassment by your employee needs to stop, because they need to protect you from that. Okay? All right. There are two basic types of sexual harassment: quid pro quo and hostile work environment. The first, quid pro quo, the term is Latin for this, for that. And this is the kind of the original form of harassment that the courts dealt with, where the employer, either the boss, the owner, or a supervisor who is considered the employer, as far as the courts are concerned, they make conditions of employment based on sexual favors. So an example is the boss comes, the supervisor says, there's a promotion that's coming open, and if you want to be considered for that promotion, you'll come to dinner with me tonight and back to my place afterwards. That is making a condition of employment based on sexual favor. And it's a clear form of harassment, one that's been around long enough that the courts absolutely do not tolerate this type of harassment. It's committed by a supervisor on an employee that they have authority to grant or withhold benefits from. So a co-employee cannot commit quid pro quo. They may pressure you with sexual favor a lot, but that still is not quid pro quo, because they can't change your employment status as a co-employee. So it's supervisors on employee. So what about the situation where it's co-employees harassing you? Again, that's hostile work environment, hostile workplace. And the harassing conduct that creates an intimidating, hostile, or offensive work environment for any employee, customer, or vendor to the point of interfering with the workplace performance is hostile work environment. A couple of things that we added there. Again, I talked about that the employee needs to protect you from harassment from others, and that includes customers and vendors. So if you've got contracted IT people coming in that you have to work with, a janitorial crew that's a contractor, again, if you're being harassed by them, report it. Doesn't matter that they're not actually your co-employee. You're subjected to that harassment because of your employment position. And understand, you don't want to be harassing people that you come into contact with either, because their employer may come back with concerns that you're harassing them. When it comes to these hostile work environment claims, again, just so that you know where the courts are at with this, the burden of proof is on the employee to show the court in a case of hostile work environment that the behavior was unwelcome, it was based on gender or some other protected class, and that it was sufficiently severe or pervasive enough to create a hostile work environment. And that it was so severe that it affected the ability to do the job. We've already seen that test, right? That is the test to determine whether or not it's illegal harassment. So the courts are saying that hostile work environment has to be based, first of all, the conduct has to be at the level that it would be illegal harassment. And a couple of other things that the court needs to see is that the employer had knowledge that this harassment was going on, or they should have had knowledge that it was going on, and they did not take prompt action to end it. So again, under the policy, you're all required to report harassment when it happens. So the employer should have knowledge. If you can show that the employer, when you told them that that harassment was occurring and they did not take prompt action to remedy it, then you have a case of hostile work environment. But again, that's why, again, the policy requires that you report it, not only if you are the subject of the harassment, but if you witness harassment of your co-employees. You're required by the policy to report that so that the county can take action and stop that behavior. All right. The defenses that are available to the employer when it comes to a hostile work environment is they have these two defenses that the courts allow. That first of all, the employer exercises reasonable care to prevent and correct harassing behavior. So that's why we do all the training. Not just me here today, but online training and things that are available. And when reports are made of a hostile work environment or other harassment, again, every single time an investigation is going to be done. That's what I told the supervisors this morning. Every time that a report is made, there's going to be an investigation. So that because again, the employer is required to do that, to keep an eye open for it and to correctly or promptly correct any behavior. So understand you're required to report harassment, whether you're a victim of it or you just see it. And once it's reported, it's not your decision whether or not an investigation is going to be done. It will be done. Okay. The other defense that the employer has is that the plaintiff employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to avoid harm otherwise. And what that says is, under the policy, if you're not happy with the investigation, the results of the investigation that were done, or you're not happy with the discipline that was decided upon based on the investigation, you can grieve that. And there's a process in the policy for you to file that grievance and have it heard and determined. What the court is saying here is, if you skip that and you don't take advantage of those opportunities to grieve in your employer's policy, and you try to just go to court then, they're going to throw that case out. You don't even get a hearing because you failed to take advantage of those opportunities to allow the employer to deal with the issue. So don't, protect your right to go to court if you are a victim of hostile work environment or harassment. Don't skip those opportunities that are available to you under the policy to grieve and question the actions by the county. Okay? Clear? That's really important. Retaliation. We touched on this earlier, but any action against an employee for complaining of, providing witness statement about, or otherwise supporting a victim of discrimination or harassment is retaliation. And this is a really touchy issue for the courts. So much so that we've got a couple of cases that we're defending right now that very early on the court determined that there was no illegal harassment or hostile work environment, but we're still defending the claim of retaliation. That even though the behavior that the employee complained of and said was harassment wasn't illegal harassment, the court said that doesn't matter. If they were retaliated against for reporting it, we want to look into that very closely. So understand as employees, you should expect that you're not going to be retaliated against. If you report or you're a witness to or you support somebody that's bringing a case of harassment. If you are feeling like you're being retaliated against, you need to report that under the policy to your supervisor, and understand if one of your coworkers has made a complaint and you know that there's an investigation on, you do not retaliate against them. If you retaliate against another employee for having reported a claim of harassment or hostile work environment, you will be disciplined. We cannot allow that to be happening. This is where cases get really difficult to defend and really expensive, is when there are claims of retaliation. So if you know that that's happened in your department, you do not treat those people differently. You don't avoid them. That's most people's first reaction is, wow, if they're the type that's going to make a claim of harassment, I'm just not dealing with them anymore. You can't. You need to continue to work with them the same way you always have. Unless, of course, you were one of the people that was harassing them and you stopped harassing them. Right? Again, the courts are really intolerant of this, and that's why I tell the supervisors, they don't just wait for these things to come to them. They need to be on the lookout for them. So expect that if someone in your department makes a claim that they feel they're being harassed or that there's a hostile work environment, you're probably going to get called in by your supervisor and reminded not to retaliate. And again, if under the policy, if you do retaliate against another employee, you'll be subject to discipline. Under the policy, either as a victim or a witness to harassment or hostile work environment, you can report that to your supervisor, to the department director, to Human Resource Department, or the county attorney's office, any of those. So if you're uncomfortable going to your supervisor, you can go to the next level. Chain of command does not apply here. You can go to any of those directly to make sure that it's reported. And again, an investigation is going to be conducted each and every time that a report is made. Your responsibilities as an employee when it comes to harassment and discrimination is to make sure you attend the training. So if you came in a minute or two late and you didn't sign in, please get signed in, or Jenica's going to make you come back at 11 o'clock and do this again. Report all discrimination and harassment, and comply with the county policy. Assist with any investigation that's going on in your department. Again, utilize the grievance procedures of the policy. If you disagree with any actions that are taken, I want you to protect your right to go to court by doing that, and do not retaliate against other employees in any way. Those are your responsibilities. And I just put this in here at the end again because it's really important that all employees understand the difference between illegal harassment and harassment that's a violation of the policy, but it doesn't rise to the level where we go into the court system. And I don't want anybody leaving this training thinking, yeah, the guy that did the training today kind of blew off harassment and said that most of what's going on is not an issue. It's an issue because when there's any offensive behavior, we leave that productive workplace there at the bottom of the scale. And now we're less productive as a workplace because of that offensive behavior, whether it rises to the level of illegal harassment or not. That's why the policy, what's a violation of the policy, is a much lower threshold than what we've been talking about is illegal harassment. And once that offensive behavior becomes unwelcome by someone, now it's creeping up to the situation where it can become illegal, but it clearly is a violation of the policy at that point where it becomes unwelcome. And once that unwelcome offensive behavior alters someone's ability to get their job done, now it's illegal. We never want to get that far up the scale, folks. As soon as you spot offensive behavior in the workplace, you should be reporting it so that it can be dealt with under the county policy. Okay? Questions? Yes?
If the county becomes aware of hostile work environment without a formal report being made, is there still, what's the action then?
When I do the supervisor training, again, I tell them they need to be on the lookout for that hostile work environment, and if they see it, they need to take action. The persons who are creating that hostile work environment, you know, again, investigation needs to be done, find out what the root cause is. If it's found that it's harassment that's not based on a protected status, it's probably still going to get dealt with to get rid of that, you know, activity. But if it has to do with a protected status, there's probably going to be some discipline meted out against the persons who are creating that hostility within the workplace. So the supervisors will be on the lookout for it, but again, if you see it or suspect it, under the policy, a witness is required to report it. So report. You know, county attorney's office and HR get pretty good at doing the investigation. So you know, they would prefer to do the investigation than to not have heard about it and let it get worse. All right. Thank you. Appreciate your time.